Thank you for tuning in to another edition of Work Comp Matters videos. This time on the show, I am thankful that we have employment attorney Liat Cohen from liatlaw.com, and we're here talking about employment in California. Thank you very much for joining me.
Thank you.
You've been an employment specialist attorney for about 25 years in California, and I've got a couple of questions that I know I want to ask you, and I'm sure all of our viewers do as well. As you know, California is an at-will state. Can you briefly tell our audience what an at-will state is?
Certainly. In California, employment is considered at will, which means that an employer can terminate an employee for any or for no reason, and in the same way, an employee can quit their employment without giving a reason to the employer.
Now, my understanding is, with the exception of what I refer to as the Title IXs or violating your civil rights, you can violate an employee for any reason. But for example, whistleblower, skin, age, religion, you cannot fire an employee for those Title IXs, correct?
Correct. When you are terminating an employee who is an at-will employee, meaning they don't have a contract of employment with you, what you have is the right to terminate them for any reason, as long as that reason is not of a discriminatory nature. And in California, what we have are protected classes that are reasons that are not to terminate an employee. For example, the ones that you mentioned, if someone is a whistleblower, there's race, there's gender, there's national origin, there's pregnancy, there's gender association. There are about 15 to 20 protected classes in California, and certain cities have their own protected classes. For example, San Francisco includes height and weight as part of a protected class. Yes.
Wasn't there a case a while back where an employee from Hooters was fired because she was overweight, and that was not against the law, or am I mistaken?
No, that is correct. That was a big case.
But if it was in San Francisco, then the former employee would have been compensated.
Correct. Now, if you hire an employee for a certain job, then you have the right to make sure that the employee fits the requirements for a certain job, as in Hooters, or as a better example, maybe for a driver for a pizza company. Then you have the right to make sure that the person has a driver's license and the person's licensed to drive a car, because that's a requirement of employment. And you can terminate that employee if they don't have a driver's license or if they don't have the requirements for employment. But if you terminate for a discriminatory reason, that's what you got to watch out for. Even though employment in California is at will, what you don't want to do is terminate for a discriminatory reason. For example, if one of your employees becomes pregnant, you don't want to terminate her because she's pregnant. However, you can terminate her even though she's pregnant, as long as the reason is not the pregnancy.
Talk for a moment about FMLA. I know that the employer is required to keep the position available for a certain amount of time, but I'm not certain about whether or not the employer has to pay any monies extra keeping the job open. Can you talk about that a little, please?
Absolutely. FMLA is the Family Medical Leave Act, and it applies currently in California, as in nationally, to employers with 50 or more employees. Employers with 50 or more employees are required to give unpaid time off to employees who want or need to take care of family members.
What's the maximum amount of time off?
The maximum time off is 12 weeks.
Okay. And
unpaid, but they can use their vacation time.
Okay.
And it doesn't apply to all employers. Again, it applies to employers with 50 or more employees in California.
Let's talk a moment about hiring and firing in workers' comp. What is an employer allowed to ask a prospective applicant or employee when they are applying for the job, and what are they not allowed to ask?
That's a very good question. An employer is allowed to ask basically all interview questions when hiring an employee, as long as it does not invade the employee's privacy or it does not touch upon a protective class. For example, an employer is not allowed to ask a female employee if she's pregnant or if she's planning to be pregnant. An employer is not allowed to ask a, let's say, Muslim applicant if he has to pray 5 times a day and he has to take 5 times out of his work schedule to pray.
But you can ask that same Muslim applicant if he has any personal life or medical restrictions that would prevent him from doing the job without specifically asking about those restrictions. Am I correct?
Absolutely. And that's absolutely true. So, for example, if you believe that you're hiring a lady who might have kids that she needs to pick up at 3 o'clock from school, the correct question would be, do you have any
Child care responsibilities.
No.
Oh, really?
Yeah, the
Oh,
correct
okay.
question would be not do you have any child care responsibilities, rather the correct question would be do you have anything that would prevent you from working our full day here, which is 9 to 5? And that's what you would ask. So you would ask it from the employer's point of view, is there anything that would prevent you from working a full day of work 9 to 5? Is there anything that would prevent you from coming in on a Saturday if we needed you because your job requires that we need you 1 Saturday a week? Now, if you're hiring somebody like a driver, then you're allowed to ask, do you have your own car? Otherwise, you're not even allowed to ask a prospective employee if they have their own car, or because they can get to work, as far as they're concerned, by any means that they want, including the bus.
And didn't Governor Gavin Newsom, I think last year, institute some new law about hiring where literally you cannot ask a prospective employee if they have a prison record or something like that? That just came across last year?
That is correct. That's a new rule, although you necessarily wouldn't ask somebody if they have a felony record. However, once you make a preliminary offer of employment, you can do a background check which includes a felony record with the permission of the prospective employee. So naturally, it would make sense in the real world if an employee who had a felony record would tell the employer right off the bat, especially if, for example, you're hiring somebody to be a bookkeeper or to be somebody in the accountant department and they've had a felony for embezzlement, then you would think that they would come through and tell you that themselves. So an employee can volunteer anything in an interview that they want, whether it's personal nature, whether it's accommodations they need for a disability, but you cannot not hire them because of that accommodation. For example, let's say an employee in an interview, prospective employee, said that they have diabetes and they need 5 breaks in order to check their sugar level during a 5-hour period. Now that is very valid, and if you can reasonably accommodate that disability and reasonably make accommodation for the employee to test their sugar level, and the employee is great in every other way, you can hire the employee. Now, if you do not wind up hiring the employee, you have to make sure it's not because of the reason that they are a diabetic.
I got to ask you, what's the difference between a reasonable accommodation and an unreasonable accommodation?
A reasonable accommodation would be one that does not create an undue burden on the employer. So if you have a company with 500 employees, you can reasonably accommodate an employee that's a diabetic and that has to go check their has to go check their insulin when there's 30 people in their department. If you're hiring a front desk receptionist that has to be on call except for her breaks and lunch breaks, and you have 3 people working in your office, it would be an undue burden for somebody else of the 3 people to take her place every time she went and checked her insulin. So it has to be reasonable, and it has to be not an undue burden on the company.
Drugs and drug abuse are constantly becoming more of an issue in California. In addition to the legalization of marijuana in California, how has that come into play with hiring, firing, and just the standard workplace? Where What have you seen regarding drugs in the workplace?
What I've seen is two sides of the pendulum, and it swings in both directions depending on the situation. I have a client that insists on putting in drug testing into their employee handbook and insists on doing random drug testing for employees in the workplace. I recommend against that. I don't like that pendulum swinging in that direction unless the employee his job is directly related to some issue of safety or OSHA or they're federal employees, in which case you're allowed to drug test them. Now, you cannot drug test an employee or a prospective employee until you've made at least an initial offer of employment. And so once you've made an initial offer of employment as a contingency of getting that employment, that is the time to do the drug testing. If an employee comes in to work and they're clearly inebriated or they're under the influence of something, technically you can ask them to go and do a drug test. But you really don't need to, because if they look inebriated, you can tell them to go home. Or you can fire them.
You can fire them because California is an at-will state, and
Exactly.
it's not being intoxicated is not one of the protected classes.
Exactly. So there's really no need for the drug testing or the marijuana testing. And even though marijuana is legal in California, it does not mean that you can come to work high on marijuana.
Oh yeah, opioids, antidepressants,
Absolutely.
all prescription drugs are arguably legal in California as long as you have a doctor's prescription.
Correct.
But it doesn't mean you can come. We're almost out of time. I got one last question. Everybody's saying, Steve, you should have asked it before. Sexual harassment. With the
That's a
Me
good
Too
one.
movement, oh, the lights are going on. Sexual harassment is huge. What defines sexual harassment? What is it at its core? And I mean, we clearly know if I'm going to back someone into a corner, that's sexual harassment. But sexual harassment could be as simple as, I like the way your blouse looks. Please, let's talk about that. And then I could spend another hour on this, but we're out of time.
Let's talk about my blouse, or let's talk about sexual harassment?
Let's talk about sexual harassment.
All right, sexual harassment. So actually, the law just changed, and it used to be that sexual harassment had to be severe and pervasive, which means ongoing to the point where a reasonable person would find it offensive, or it had to be one action that was totally so absurdly harassing that no reasonable person would say, oh yeah, he cornered her in the bathroom and took off her skirt. Oh, okay, that's sexual harassment.
So
There's
is
no
sexual
question. But
harassment...
let me finish.
Sure.
The law just changed, and it is now enough for one action in the workplace to constitute sexual harassment. So the law is even stricter starting this last year than it has been up until now. And it does not need to be severe and pervasive, but one action can constitute sexual harassment.
Is sexual harassment no longer a unwanted sexual advance?
It has to be unwanted by, if it's a consensual relationship
Then it's
between
not
two
sexual
employees,
harassment.
then it's not sexual harassment. If it's a consensual relationship between an employee and a supervisor, it's still a situation where it's potentially sexual harassment and the employer has to step in because the supervisor is in a supervisory role over the employee, and it could easily be looked at as a intimidation type of situation.
That is fantastic. Thank you so much for coming in. My name is Steve Appel. You've been watching another edition of Work Comp Videos. This one has been on employment law. My guest has been Liat Cohen of liatlaw.com, and I thank you very much for coming in.
Thank you. It's been a
We'll see
pleasure.
you all next time. Bye-bye.